All rise. We will wait. Please be seated.
Thank you very much. Mr. Hooper, you said you were done with your...
I am, Your Honour. Yes, thank you.
Right. Mr. Keegan-Cartwright, if you can put on record your position.
Mr. President, Your Honours, I do not intend to cross-examine the witness, and I sent an email a short while ago to explain that that is the position.
That is why I said you needed to put it on the record instead of an email.
I am obliged, Mr. President.
Thank you. But I
President,
will...
may I explain the reason why I sent the mail? I think it is already in the mail. It was just a matter of courtesy, just in case any arrangements need to be made for next witness. It was not meant to communicate by way of mail what I ought to come and say in court.
And now, where does that leave us, prosecutor? We're not discharging the witness. I have some questions. And after asking the questions, Mr. Keegan-Cartwright, you still will be free. If you feel that there are some questions arising from mine, you're welcome to follow up when I ask them. Okay.
Right.
Your Honor, in regards to this witness, it leaves us simply with the submissions in regards to the admissibility of the expert evidence and the two documents that I had initially spoken about this morning. As for the next witness, the team that's going to be examining that witness is present in court, so we'll be able to change in short time, if there is indeed some time left for that, to start out at least with the other witness.
Is the other witness around to be put on this? All right, it looks like because of the uncertainty.
We may have jumped the gun, but the team is here in court. Should the witness find his way here at some point, or should we have some time? If not, we'll be happy to start out with the witness tomorrow morning.
That's fine. We also have work to do if we are not sitting in court. So there's no time wasted involved. But I do have questions, Mr. Ken. Yes?
Of course, Mr. President, I'm not intending to delay matters. Just in relation to the next witness, as it's been mentioned, we haven't received yet the VWU's assessment and recommendations regarding protective measures, and of course we'd like to see that before the witness is brought into the courtroom, and I'm grateful.
In light of the litigation on the...
Indeed.
Yes, okay, usual litigation. All right, witness, I have some questions for you. Yesterday, you testified to the question of, we're talking about the Rift Valley being reserved as the White Highlands, as you put it, during colonial period. And eventually, even when independence came, there were still some issues with redistribution of land in the area. And your explanation, or rather part of your testimony, again, please correct me if I get it wrong, was about the preponderance of the redistribution resulting in Kikuyus owning quite a bit of land in that area. Now, today, in the testimony, you also said that Kikuyus also had lost land in the central region. Is that correct?
Yes, indeed. During the colonial period, the Kikuyus also lost a lot of land, given that near Nairobi, a lot of land was given to white colonialists during that period. And so there was land pressure put on the Kikuyus, very strong pressure, which led them to looking for land elsewhere. They pioneered other areas, and the Rift Valley was considered very early on as a potential area where they could expand in one way or another. During the colonial period, they would go and work on the white farms, but later on it took on different forms. That's basically the answer.
Was the loss of land that the Kikuyus suffered in the central region, was it all explained by expropriation of their land and giving it to white settlers, or did it also have to do with building a capital territory, that is Nairobi?
There are a number of factors. The two elements, indeed, were true. On the one hand, the white settlers took a lot of land near Nairobi, and there was also pressure in terms of land ownership because the social stratification, the class differences became very clear very rapidly amongst the Kikuyu. The more wealthy Kikuyus, for one reason or another, grabbed land, a lot of land, so that a lot of other Kikuyus didn't have any land. So there was, on the one hand, social differentiation, the fact that the white settlers took land and that Nairobi was expanding. All of those factors led to the fact that many Kikuyus needed land, wanted land, and very early on, in fact.
What about the factor of, as I said, building a capital territory, which perhaps, again, you are the expert, correct me if I get it wrong, might have involved needing land for government purposes, public parks, public buildings, where actual government need for legitimate running of the country could be explained. Did that also happen? Taking land for public use in Nairobi?
Yes, but it was not the major aspect. The major aspect that put pressure on the land ownership was that Nairobi was expanding, and therefore the value of the land near Nairobi went up, in particular for vegetable growing and other products, other farming products that could be sold rapidly in Nairobi. So the cost of land went up, and therefore the richer groups took over those areas, and many poor people ended up landless. In the history of land ownership in this area, the Mau Mau crisis also made it possible for certain social categories to grab land, and meant that a number of social categories were left out in the cold. The Kikuyus were in need of land. Their need was the most intense. And this was seen as a major political issue that the first government needed to solve very quickly.
So, as far as you know, the incidence of the state's exercise of the right of eminent domain, as it were, was minimal. Do you understand what I mean by the right of eminent domain? I can explain it.
Yes. It was minimal in Central Province, but in the Rift Valley, yes, indeed, the state played a very important role. The land ownership system, the state-owned land system, if you will, existed first of all in the Rift Valley, and not at all, virtually not at all, in the rest of the country, just a wee bit in the coastal province. of course, there were public lands elsewhere, but it didn't have a major influence on the population. It really played an important role in the Rift Valley because the state controlled a lot of territory. The settlement schemes developed because of the relationship between the occupants of the land and the state, the direct relationship, and that's why the land became a political issue. And in a period with multiple parties, you go to the state, and there were, during electoral periods, this was a very sensitive issue.
What I mean is, by eminent domain, is there's this notion in international law in particular that the sovereign is entitled to expropriate land or property for public use, and ideally for public use, not to give to friends and family, but for public use. Ideally, there should be compensation, but if the state cannot pay compensation, then everybody should chip in and bear the burdens of, living together. We're all in it together, as it were. Whether that might have had any role to play in the sense that Kikuyus being dispossessed of their land in the center for public purposes, therefore state said, well, we have to, these are Kenyans as well, we have to find them land somewhere. Oh, it's in the Rift Valley. Was that it, or are you saying it had very little to do with it?
J'ai du mal à répondre.
It's difficult for me to answer that question because I don't think that the reasoning, if you will, was in those legal terms. In the Rift Valley, the idea was more national citizenship. We have to find land for people who don't have land. And there wasn't this idea of eminent domain. It was a political issue in the idea of national citizenship. We must find land for all of those people who are landless in the country. It's part of the social contract that was set up at independence. And therefore, everyone should benefit from such a policy. That was the reasoning. That was the political discourse. But over and beyond that, there was a concept which was unequal, if you will, in terms of land distribution. The fact is, land was distributed unequally. Officially, that was not the case.
That is all. Thank you very much.
Mr. Witness, just one question. You said that the land issue became part of campaign before 2007 elections. I suppose that political parties, when referring to this issue, came with promise to solve this issue by legal tools, I mean by some amendment of legislation. But have you also observed any hidden or maybe even public tendencies to indicate that there are also some alternative measures how to achieve this goal? I mean, some indication that even violence could be used in order to achieve this goal. By some political parties or by some political leaders.
Well, in 2007, ODM was very careful to be reassuring in their discourse. The PNU had been threatening the risk of ethnic cleansing, in particular vis-a-vis the Kikuyu people in the Rift Valley who were going to vote for the PNU anyway. And so this led to a communication policy on the part of ODM that was very cautious. And they were saying, let's not confuse the Majimbo in the year 2000 and the Majimbo in the 90s. So they did try to reassure the various communities that lived in the Rift Valley in particular. Now, did it work? The problem is, at the very same time, everyone knew that the local officials in the entire Rift Valley were spreading hate speech and hate messages vis-a-vis the population, and so there was a dual discourse, if you will, and that fear remained. So, depending on the level, or rather, depending on the level of political communication, the message was not the same. And the risk, this fear of violence in 2007 was quite clearly present. It wasn't a surprise. It was all the more not a surprise, given that the pre-election period was very agitated. There were many people killed, in particular in regions where there had been traditional ethnic conflict in Curaçao and other regions. In Mount Elgon, it was very violent. So the situation was such that it was like it was ready to burst, if you will. And there was agitation on both sides, and it was known that violence could be used. Not that it was definitely going to be used, but that it could occur. It wasn't excluded. And that's why that electoral campaign was extremely tense, very tense.
Thank you very much.
Council, any questions arising from those put by the judges?
No, thanks, Your Honour.
None on that part, Mr. President.
Your Honour.
We will excuse the witness and then we will discuss your matter. Witness, thank you very much for coming to answer questions from us, and we particularly noticed that you did this under some special strain of. We heard you coughing quite a bit this morning, and we thank you very much for bearing with us. And safe journey back. You are now excused. Thank you.
Je vous remercie.
Thank you, Your Honor.
So we're now left with the matter of, you said you wanted to make submissions as to what to send out?
Indeed, Your Honour, I'll be quite brief. This morning, I indicated that we would like to introduce several items of information, of evidence that the witness commented on and referred to into evidence. And those would be, obviously, the expert report, first point. The English transcript number is 00931308. French is 00930871. So I'll deal with those items of evidence first, and obviously afterwards I'm also going to be making submissions on the admission of two documents that I already indicated this morning earlier on. I'll give the ERN numbers later on. So first and foremost, in regards to the evidence expert report of the witness, I'm guided obviously by the Chamber's decision, decision 844 at paragraph 14, where the Chamber indicated already to the participants, the criterias which it felt were necessary in determining the admissibility of the expert report. And basically, the Chamber relies upon a decision in Lubanga, decision 1399, and the criterias are quite simple. It's a question of relevance, the question of probative value afterwards of the document, and third and finally, the most important question is the question of whether the prejudice would override the probative value of these documents. Our submissions, Your Honor, is that this expert report is highly relevant to the issues at hand. First, the first question that one should ask itself is obviously if this report has been is important or instrumental for the Chamber in understanding the evidence that has been given and evidence that will be given in the future. We submit that that's the case. The expert report has been referred to by the witness during his testimony. It deals with 12 questions that are highly relevant. 6 of them deal with the PNU and the ODM. I'm not going to go through every individual question, obviously. The questions that were addressed in the expert report were the PNU, its roots, how was the voting for the PNU during the elections, if it was cut on ethnic lines. For the ODM, the same questions were put to the witness. Other questions that are highly relevant for this issue and for the case are the root causes of the post-election violence. Now, that was question number 1 in the expert report. The witness, obviously, as an expert, as he has been deemed by the Chamber, gave highly relevant information as to what he determined and what other experts had cited as the possible root causes. The final questions of the expert report deal with, obviously, the ethnic tension and how the voting was done under ethnic divisions, ethnic lines, and most importantly, the last 2 questions, questions 10 and 11, which dealt with obviously how the violence in the Rift Valley differentiated or distinguished itself from the violence elsewhere in Kenya during the post-election violence, which once again is highly relevant information. And finally, if this cyclical violence had occurred in the past and the reasons why. So the witness has been with us for approximately 2 days, and he's given evidence on all of these topics. And actually, on this point, the expert report and his testimony in certain cases are inseparable. The witness has either been referred to the expert report for clarifications on certain things that he would have, certain allegations, statements that he makes in the expert report. I've examined him on those specific subjects, and during the cross-examination of Mr. Hooper, obviously, he's also referred to certain allegations. So already, even in this case, in the first criteria of relevance, the report and the testimony of the witness are inseparable, indissociable in certain regards. So that's a criteria that the Chamber must take into consideration. I don't think that the relevance will be in dispute, but those are my submissions regarding the relevance. Now, there's obviously the question of the probative value. Some of what I've stated for the relevance obviously applies in that regard, but even more importantly, when you look at the expert report, and I went through with it with the expert, one can see that these are not simply conclusions or unsubstantiated allegations that the witness has made. In response to the 12 questions, the witness has provided for each question the citations or the sources which he feels were the most relevant for each question. And also he's provided a lengthy bibliography. I've questioned him on certain of those sources to see exactly what the reliability of these sources was. For example, I questioned him on the articles of Gabriel Lynch, amongst others. And I understand that as well Mr. Hooper, during his questioning, also referred to documents or authors that were in the bibliography to test, obviously, the reliability of what the witness was saying in regards to certain in regards to Moy, in regards to the elections in 1992, elections in 1997, elections in 2002, and finally the elections in 2007. So all of these elements, all of this information that the expert has provided is extremely relevant. In fact, it's always been the prosecution's pleading and submissions that what happened in the past 1992 and in the previous elections is highly relevant in understanding what happened in 2007. So the expert has explained that to us. It's obvious from the way he's expressed himself that some of the conclusions that which he arrived on are conclusions that derive from his own research, and other conclusions are those that he's derived at from his understanding and his reading of academic material and articles. I understand that at one point defense counsel mentioned that this might be an issue in regards to admissibility. Our submissions is that this only goes to weight and not to the admissibility. The final criteria that the Chamber has indicated for the expert report in its paragraph 14 is the question of whether the probative value of the expert report is whether there's obviously a probative value and what prejudice there may be. In my opinion, my humble opinion, the most important factor in this regard is that nowhere, whether it be in the testimony of the expert or in his expert report, is there any indication or any information or evidence that goes to the acts and conducts of the accused, either of the accused, in regards to the charges that are put to them. The expert witness has been quite careful in his report to simply give information as to, and even obviously when he's asked questions as to who are the people involved, he gives out simply descriptions as in opinion leaders, Kalenjin youth. He's never mentioned any type of evidence or any type of conclusion as to the criminal responsibility of either of the accused or anyone in the network that the prosecution would have mentioned in its pretrial brief. So that's an important consideration. There is nothing that could be prejudicial to the accused in terms of a fair trial. As for the probative value, Your Honor, I've already indicated that the relevance, the document, the expert report, is highly relevant. It explains in detail, indicating the sources.
I thought that was the criterion of probative value. When I noticed that whenever you were addressing the criterion of probative value, you also start talking about relevance.
For probative value, Your Honor, I think that the factor which is the most important is the fact that obviously all the sources, the bibliography is indicated. If the defense wants to challenge or needed to challenge the witness on any of the material or any of the conclusions that he arrives on, it was the sources were readily available. So that's the most important factor for the reliability of the expert report. One last thing that I'd like to mention in regards to the expert report, probably one of the most important things, is that according to the conduct of proceedings decisions of the Chamber, decision 844, if my memory serves you well, paragraph 26, if we wish to introduce an item of evidence through a witness, there has to be a connection between the testimony of the witness and the document. In this case, obviously, the witness has referred to it on many occasions, and questions have been led using the expert report. So those are basically my submissions in regard to the expert report. One last thing I wanted to say in that regard is, just to sum up, is that I don't see why, for any valid reason, that the Chamber should be deprived of all the information that we do find in the expert report, because obviously the expert witness has given us the information which he found the most important while testifying, but there is a more in-depth study on certain points that is in the expert report. The Chamber is here for determining the truth in the matter, and I think that it can rely on the rest of his evidence in light of the fact that he is an expert witness in the matter.
Ms. Hooper? On the report.
Yes.
Mr. Garcia has not yet spoken to the other two other documents he had in mind. He had brushed earlier. Now we're dealing just with the report.
Our position is to really tread with some care. There's no ICC jurisprudence that's of very much assistance to the Chamber. This is a matter, this area of expertise, expert reports, that hasn't received much, barely any attention from any chamber. And so the consequence of that is that the parties, particularly the defence, are unclear as to the parameters within which a report, for example, such as this, once admitted, the parameters within which the contents of that report could subsequently be used or employed. We're also aware that we're dealing with what I submitted, in fact, at the outset on Monday, was a unique area of evidence, unique in the sense of being unique to these kinds of courts. ICTY, ICTR, of course, are familiar with reports that go to the backgrounds of the case, the history of the genocide in Rwanda, for example, and its previous colonial history from Alison Deforge, Ratians and the others is well known. And to a lesser extent also at the Yugoslav Tribunal. There are experts who spoke in some general terms about, though generally about more specific subjects such as lines of command and political and military structures. Particularly in terms of what I'd call the quasi-historical reports or experts, these are not expert reports in the sense that we would be familiar with in our own domestic jurisdictions in any way. There, of course, one would tend to have particular subjects addressed of a technical nature. The person who'd come to court to help on a whole diverse range of issues, whether it might be a metal fatigue in a plane or perhaps a physiological evidence emanating from a radiologist, for example, as to whether child injuries were deliberate or not, DNA evidence, a whole range of material such as that comes within an area where basic facts are established upon which the expert assists the court by presenting his opinion, often on a fairly discrete area. And that opinion is generally, I'd say, science-based, and therefore subject to peer review. And that, I submit, can be distinguished from the generality of the kind of historical expertise that a witness such as Dr. Maupert demonstrates, where he's expressing an opinion, in this case, based upon the opinions of others. And that's the trail that gives rise to some difficulties. Now, coming to this report, there's no automatic admission of this kind of report in our submission. Certainly that would reflect the jurisprudence of the tribunals and would be consistent with the discretion in respect of evidence that obviously arises in Article 64 and Article 69. The report, therefore, would not be admitted automatically, and so there must be parameters that it must satisfy in order to be admitted. And one of the first questions that we're concerned with, and perhaps the principal question, is this: for what purpose is the prosecution seeking the admission of this report? Is it to be viewed as containing additional evidence to be relied on in the course of Your Honour's considerations later? Is it, as it were, supplemental to the evidence that's being given? Now, as far as the evidence that's being given, we know that this is a court that has exercised the principle of orality in having witnesses testify, and this witness is really no exception to that. Now, he's been giving evidence not for 2, but really for 3 days. The prosecution have their report, which is a guide to them and informative to us of the parameters of the witness's potential evidence, the prosecution have had every opportunity to extract from the witness all the salient aspects that they seek to rely upon and adduce. And in doing that, they put the defence on notice of those areas that the defence have to address. Now, what therefore is left? Not all the matters in the report have been adduced necessarily by the prosecution, and consequently and naturally, not all the points in the report have been addressed by the defence, and nor should they be expected to respond to matters which have not been laid before the court directly through the oral evidence. So we would submit that if this report is admitted, then it should be, if admitted at all, be admitted within reasonable parameters, admitted indeed in order perhaps solely to illustrate the reliance that is placed by the witness in coming to certain opinions on the opinions of others. In other words, as a reflection of his methodology. What we strongly submit is that parts of the report that have not been laid before the court could not become substantive evidence in this case. So those are my submissions in respect of that report.
What did you say happens in national jurisdictions as regards admissibility or admission of expert witnesses' reports?
Well, first of all, what I submit is that I can think of no case that's ever come before a court in my jurisdiction where this kind of report, this kind of evidence is given, of this kind of generality.
Not of this kind I'm talking about, where an expert of any sort has been called. What happens to the report by way of admissibility?
The report wouldn't be admitted. Not in a criminal case. The report obviously goes into the filing bundle in terms of a civil proceeding. But in terms of a criminal case, it wouldn't. And that's a reflection, in part, obviously, of the nature of the system. You wouldn't be providing juries, for example, with that kind of report. And what I submit would obviously be the case, and that is that the evidence, the oral evidence, is the evidence that matters, what's given in court. And the expert can express his opinion, and the expert can demonstrate the facts upon which that opinion is based. But one of the difficulties here is that there are facts that may be relied upon by the expert, as we explored this morning, that are untrue. They cannot be viewed as facts in the case at all. And they don't come into the case as facts that have now been proved because they've been referred to perhaps by an expert, or even more the case, facts that have been relied upon by someone else to express an opinion upon which this expert has gleaned a summary. And you may recall almost the opening words of this expert's testimony when he said, as far as this report is concerned, and I haven't got the direct quote, but I have got it in my papers if you want it, you may recall it, he said, "This report is not my view of the violence, but the view of others." And you may remember that this is not an expert who's done any primary research even to rely upon. So there's no facts that he attests to in the course of this report that are primary, not even secondary. What one has here, in effect, from time to time, and this is our concern, is a tertiary hearsay of complaints made, perhaps to tribunals, to NGOs, unsourced in the reports that he's read, whether they're by a Gabriel Lynch or by a Moeller or Klopp or whoever.
I'm merely trying to establish what's done in other places. So I've asked you the question about national jurisdictions. You've answered it. We have an opinion on that. But what about in the other tribunals, the ad hoc tribunals? You had mentioned reports there, including Alison Desforges and others. What happens there as well?
I must say, in terms of my knowledge, from direct experience, are rather limited, and probably far less than the Chambers. But the principle, as I understand it, remains the same, and that is that which is adduced as opinion, founded on proven facts, is, of course, evidence in the case. But matters that are not expressly accepted, which lie somewhere within perhaps a long report, can't be used, surely and logically, as substantive evidence in the case later, to find their way into a prosecution closing brief without further ado. That wouldn't be a right process to allow. And in particular, when you have this kind of wide-ranging, opinion-centred material, which we've been dealing with in this case. So we're dealing, so I come back to the beginning, to a very special and exceptional form of expert evidence, wide-ranging, not specific, not rooted in specific facts, and very subjective, and for those reasons requiring, in our submission, a very cautious approach. And the best cautious approach is to rely solely on the evidence that's given orally. The prosecution have every opportunity in this case to extract all they wish to do to obtain from this particular witness. It's not like, for example, the ICTY, where the statement can go in as a preliminary document and then cross-examination takes place under Article 92, 94. In this case, the prosecution have had their time with the witness. What is it that the prosecution want this report to do that they haven't got their expert to do? There's our concern. It's unstated, isn't it? And we're right to be suspicious about it.
So it's all right. Mr. Kigen-Katwa?
With your permission, Your Honours, my colleague Caroline will take up the objection.
Ms. Bestman, please.
Good afternoon, Mr. President, Your Honours. On behalf of the Sang defense, we also object to the admission of this report. We see in particular no added value to admitting this report. We've heard from this expert for 3 days, and any relevant parts of the report will have been addressed either by the prosecution or by ourselves or by you, the judges. Any other parts in this report are basically opinions, untested opinions, based on other untested opinions. And we know from this witness himself that his expertise in relation to the Kalenjin culture and the Kalenjin customs is only based on what other people have said about it. He has no personal information about it. That's what he said himself. So in that sense, to the extent that this has been tested, we have no objection. But to admit the report in addition to that would be a problem. So in the sense of relevance, if you go through the three criteria, relevance, we see no relevance because, as I said, you've heard from this expert, and anything that anyone wanted to ask, this was the time. And we cannot now read anything that wasn't addressed and assume that this is as it is, as a matter of fact. In terms of probative value, we have particular difficulties because this expert has relied on various reports from Human Rights Watch, from the Kenyan National Commission for Human Rights, also the Human Rights Commission in Kenya, and International Crisis Group, and so on and so forth. And these are all documents that are still pending. They are subject to a pending application of the prosecution to admit bar table evidence, and that's 1121. We've already given our comments, as well as the Ruto defense, in the Annex A to that application. And the Sang defense, we also submitted a response on the 24th of December 2013, and that is number 1130. So I won't dwell on all the arguments we set out there. But there are particular problems with these reports because these reports, again, rely on other opinions as well as anonymous witnesses. And these anonymous witnesses we cannot test at all. And so not only do we have a report that relies on hearsay to the fourth degree sometimes, because it's opinion based on opinion, based on anonymous witnesses or other opinions based on anonymous witnesses, that cannot be tested. Mr. President, in the Katanga case, these were factors that weighed very heavily against admission of reports, and on that basis, the further remote the hearsay evidence was, the less likely the chamber was willing to admit it, and the same for anonymity. Anonymity makes it even more difficult for a chamber to accept its reliability. And I can go through all the jurisprudence, but you can also find it in our bar table motion as paragraph 22.
What was done in Katanga? You mentioned Katanga.
This was a bar table submission, and we admit this.
Not expert witness report.
No, Mr. President, but my argument is that the extent to which his opinion has not been tested here in court with you today or yesterday, the day before, it is like submitting it through the bar. So the same criteria in terms of testing the reliability, which is very linked to probative value, also applicable to an expert opinion when it's not tested in court before you, Your Honors. And so in that sense, I submit it's relevant. And it's not just the Katanga and Nkujolo trial chamber that has looked at all bar table documents and quite a number of United Nations documents as well as Human Rights Watch documents were not admitted on that basis. It's also, I can go through it, but I'm not sure that I want to waste your time, but it's because also in the ICTY and in the ICTR, similar opinions have been expressed. And maybe I'll just give you the reference to our filing, which is 1130, starting at paragraph 22, going on to at least paragraph 32. And in particular, like paragraph 30, where besides the Katanga chamber saying that information, when it's twice or further removed from its source, that's a factor weighing against admissibility. And we also have the International Court of Justice that did not want to admit MONUC reports because of its second-hand hearsay in it. And in particular when I say when it's anonymous sources. In addition, and this is something we've also highlighted in the annex attached to the prosecution application, we have particular difficulties with some of these anonymous sources because it's our submission that some of them are concocted. This is something I can dwell on, or I can leave it there. And again, I can just refer to our filings. So we have a problem with the probative value of this particular document. We already said it's not relevant. And prejudice, whilst we concede there is no direct problem, at least to Mr. Sung and to Mr. Ruto, but there are theories about organization of violence, about patterns of violence, and all of this is, of course, relevant because otherwise, or at least that's why the prosecution has brought him in. So it is prejudicial to the defense, and especially when this has not been tested properly. So on that basis, we request the Chamber to not admit this report. Thank you very much.
Mr. Garcia, reply, and keep in mind the matter raised, well, there's a lot raised by the opposing counsel, but one matter I need you to address would be the question, what else in the report? Why else do you want the report admitted? Mr. Rupert said they're quite suspicious of the use to be made of it beyond what the witness had already testified to. Can you speak to that and the rest of the matters raised or the objections raised?
Certainly, Your Honor. Just to start, obviously, this is the first time that the defense counsel objects itself to the matters that are included in the report. And what the detail is that the report, obviously, the witness explains the themes, the questions that have been asked of him, and the answers in much more in depth. That's obviously the primary answer to the question of the court. When the witness comes here and testifies, obviously the questions that have been put to him are the ones which we feel were the most relevant and cover all of the questions that he dealt with in his expert report. But it's obvious that the expert report, the witness had more time to explain his answers and explain exactly why he arrived at certain conclusions. And my basic submission is I don't understand, or what is the valid reason that's being put forth by the defense to deprive, that we should be depriving the Chamber, professional judges, of evidence or information which is highly relevant and which can explain the post-election violence and the events that occurred prior to that. The Chamber has asked Mr. Hooper and to a certain degree Ms. Bausman as to what is the practice in other chambers, in other jurisdictions. I can say that in our case, in the Canadian jurisprudence normally and in Canadian courts, when an expert witness comes and testifies, usually the expert report will come in with his testimony, and it'll be a question afterwards for the Chamber to determine what is the weight to be given to the expert report. But it's obvious that the expert witness testifying will not go into the all the details that he's enumerated in his expert report, because most of the time, as Mr. Hooper has indicated to us, the expert reports in a criminal trial in a national jurisdiction will hinge on opinion evidence, on scientific methods and sources. In this case, we have a witness that is very similar to the type of witness that we had in the case that the prosecution had in the case and proposed in the case Nahimana of the ICTR. This was a historical witness. The Chamber, in the end, accepted the testimony and the expert report of Alison Deforge. And obviously, I'm looking at the judgment in the Appeals Chamber of 28th of November 2007. This is a decision that was cited the defense counsel for Mr. Sang. And obviously, so I can see in that the practice has been at the ICTY also to include and admit expert reports so that when the witness is obviously testifying, he can testify or she can testify to the conclusions that are the most important. And then afterwards, obviously, the Chamber has all the sources and all the background, the method, or the information that the expert witness relied upon. The most basic factor and the most basic principle that protects the defense in this case is that they have all this information beforehand. So when the expert witness is testified already in chief, defense counsel can, as has been done by Mr. Hooper in this case, Mr. Sang's counsel chose not to prevail himself with that right, but can cross-examine the witness as to all the sources that are indicated in the expert report. And that's why in decisions such as Popovich of the ICTY, the trial chamber, the chamber and the appeals chamber in that case has rehearsed and reiterated that there are certain criterias in determining whether an expert report should be admitted or not. It's not something that's outstanding or exceptional. Quite the contrary. It's normal, and very much normal in cases where you have an expert witness. You don't necessarily have them testify in every one of the background material or sources. If not, the testimony will be endless. What's important is his conclusion. And I refer the chamber to, and the parties participants, to a decision of the 30th of January 2008 in the decision of Popovich and Al, and that would be page 11 of that decision, paragraph 21, and it states, as properly pointed out...
Do you have a copy for us? And for the chamber?
I do have one copy, Your Honor, but I can state the principle, and I'm sure that Mr. Hooper is well aware of this decision.
Can you read
Certainly.
the passage?
The decision, it's paragraph 21, as properly pointed out by the trial chamber, Rule 94 bis of the rules does not provide specific guidelines on the admissibility of testimony given by expert witnesses or criteria for the admission of their report. Trial chambers have established the following requirements for the admissibility of expert statements or reports. 1, the proposed witness is classified as an expert. I submit we've already had that debate in this court, and the chamber has already made a finding in that regard.
Excuse me, this goes to general expertise, the criterion for expertise, this decision.
I've just actually read out, and it's our criteria for the admission of their report. So that's quite explicit in the decision. First is the proposed witness is classified as an expert. Second, the expert statements or reports meet the minimum standards of reliability. Once again, I pled to that in my submissions. 3, the expert statements or reports are relevant and of probative value. Once again, we've submitted on that, quite similar to the Lubanga decision. And 4, the content of the expert statements or reports fall within the accepted expertise of the expert witness. So these have been essentially the submissions that I covered when dealing with the Lubanga decision, which is very similar in nature. Lubanga decision speaks about relevance, probative value, and obviously the last factor, which is probative value and prejudice. So once again, when a defense counsel states that this is outstanding and exceptional, that simply is quite not true when you look at the jurisprudence that I've just cited for the chamber.
All right. In response to my question, there are two matters there. Are you saying that you are tendering the report so that it may be relied upon at large? Or are you saying you are tendering the report so that the aspects of the testimony of the witness, for which we find the corresponding elements in the report, we're then better able to see that aspect of the testimony or those aspects of the testimony in their greater depth, as opposed to even using the report for other purposes than the testimony we heard from the witness.
Your Honor, I'm tendering the report substantively, and obviously the chamber can also rely on it to determine what the witness has stated and to verify that. In my analysis of the jurisprudence before the ICTY, there has not been a distinction in that regard. There's been distinction in that regard when it comes to underlying source material and sources, bibliography, etc., but not for the expert report. I have not seen anywhere in the jurisprudence, and I can be corrected by defense counsel if need be, where that is explicitly stated. An expert report is the witness's account or explanation of his conclusions in depth, and I don't see why we would deprive a chamber of professional judges of that information. The defense had ample opportunity to cross-examine on all of the elements that are in the expert report. They chose to concentrate on certain elements.
All right. You're done with the submissions then?
In regards to the expert report, yes, Your Honor.
the chamber will admit the report. So it will be marked as the next in the prosecution exhibit.
Thank you, Mr. President. The expert report CAN OTP 00930871 will bear the following number: EVD T OTP 00043, and will also be referenced as prosecution exhibit number 43. The English translation of the expert report, CAN OTP 00931308, will bear the following number: EVD T OTP 00044, and will also be known as prosecution exhibit number 44.
Thank you. Your next items?
Two items, Your Honor, and their documents. It's the article from Gabriel Lynch, CAN OTP 00460014, quoting the Kalenjin. It's an article that was referred to during the examination in chief and during the cross-examination by Mr. Hooper.
Where is the tab again?
It's tab 7, Your Honor, I believe.
Please proceed. Yes, it is at tab 7.
And obviously the document of, there's an article of Jacqueline Klopp, and that's Ethnic Clashes and Winning Elections, the case of Kenya's electoral despotism, and that's CAN OTP 00880672, and I believe that's tab 6. Now I'm going to be dealing with both those documents together in one submission, because I believe obviously that the same principles apply for both documents. Now, once again, Your Honor, Your Honors, first of all, the connection with the witness in these documents, the conduct of proceedings decisions of the Chamber. The first step is obviously to demonstrate that there's a connection between the testimony, and that's paragraph 27 of the paragraph 26 of the decision 847. There's a link between or a connection between the testimony of the witness and these documents. The witness referred to these documents on various occasions. They're referred to substantially in the expert report as well. I've noticed that Mr. Hooper, in his cross-examination, came back on the article of Gabriel Lynch on various occasions, seeking clarifications and additional information in regards to what Mr. Mopu had stated in his examination in chief. So we feel that hurdle obviously is that criteria is satisfied. Now there's the whole question of obviously what are the criteria that we should consider in determining whether these articles, underlying information, should be admitted. Our submission, Your Honor, is that these articles should be submitted for the truth of their content, and not simply to demonstrate that when the witness was testifying on the subjects that were touched upon by these authors, that and to obviously provide the Chamber with background information with which it could use to assess the credibility of the witness on that matter. Now, I understand that Defense Counsel gave me a heads up on the fact that he will be using a jurisprudence from the ICTY, and that's the decision in Karadzik, a decision from July 2010 from Trial Chamber and ICTY regarding the limited usage of underlying information or underlying material. And I think that the point at which Defense Counsel will be arriving is that in paragraph 7, paragraph 10 actually, the Trial Chamber seems to indicate that.
Before you address that, just so I'm sure I heard you well, did you say you were seeking the admission of these two documents for the truth of their content?
That's correct, Your Honor, yes.
Proceed.
Now, Your Honor, the ICTY decision, paragraph 10 of that decision, I'm sure Mr. Hooper will be getting into that in more depth, seems to indicate, and I'm not sure if there's unanimity in the ICTY in this regard, that underlying material, if at all, should be admitted simply for the fact of supplying or providing the Chamber with the underlying information on which the expert witness has testified on or made his conclusions so that the chamber participants, parties can challenge the reliability of the expert witness's testimony. My submissions, Your Honor, in this regard is that we don't, obviously the trial chamber at the ICC is not bound by this decision, and that the trial chamber should once again refer itself to the decision in Lubanga, which we believe is a binding, it's not binding, but it is a precedent that the chamber has already referred to in its last decision, paragraph 14 in the preliminary decision regarding the expert witness, and that the criterias that should be determined or used by the chamber in determining whether these two documents are admissible are the same ones that obviously I spoke about when I was speaking about the expert report. The question of the relevance of these documents, the question of the probative value, and the question of the weight of the probative value versus the prejudice. There's no reason in our submissions to depart from this decision. It's a decision which is encompassing, and actually when you read the decision 1399 in Lubanga, paragraph 26 clearly indicates that when the admissibility of evidence other than direct oral testimony is challenged, the approach should be as followed. And obviously they rehearse the test that I've just spoken about, the relevance, probative value, and the weight, the fact of whether the prejudice outweighs the probative value. So our submissions is that there's no need to depart from that. And in this case, we've selected two documents. There are two articles that we've selected amongst the numerous articles that are referred to by Mr. Mopur, either during his testimony in chief or in his expert testimony. Now, we were very precise in selecting these two documents because Mr. Mopur obviously was able to comment on the reliability of these. And that's why at a certain point in time during the examination in chief of Mr. Mopur, I asked him questions regarding both Ms. Gabriel Lynch and Ms. Jacqueline Clopeau. And actually, when the witness explained the importance of Gabriel Lynch, and that's at transcript 89, page 12, he speaks about the fact that it's one of the best articles regarding the 2007 elections. And he also speaks very highly of Ms. Gabriel Lynch as someone who knows about, obviously has an extensive knowledge in regards to Kalenjin politics. So that's quite relevant for the question of the reliability of these articles. Actually, also when questions were put to the witness, Mr. Mopur, regarding Jacqueline Klopp, the witness also confirmed that this was an author who was renowned in regards to her knowledge, her extensive knowledge in Kalenjin politics. So those are the two things that the witness had to say regarding these two people. And he also obviously made comments regarding the sources and the reliability of these sources. In both cases, when I questioned Mr. Ruto in this regard, he gave a certain description to the chamber as to what the sources were used by either of these authors who are recognized as being experts in these matters, and high consideration for them that the witness had. So that information basically goes to the reliability of these articles. As for the relevance, you have the document, the article of Gabriel Lynch courting the Kalenjin. And this document, this article actually, touches upon, I'm going to let the chamber obviously retrieve that document. It's Courting the Kalenjin by Gabriel Lynch. Now, it's highly relevant because obviously one of the indicators of its relevancy is that Mr. Mopur, our expert witness in this case, refers to Ms. Gabriel Lynch on many occasions, obviously explaining and citing the fact that she is an expert in the matter. Ms. Gabriel Lynch in that article deals with the election campaigns in 2007. She deals with the voting patterns. The brief political history of Mr. Ruto explains the Eldama Ravine Declaration. Also speaks about the post-election violence, the aftermath, the contested elections. Also speaks about Moy's entrance into power, the fact of how he was in Kanu, obviously, what happened afterwards, etc., and explains the attacks on the Kikuyu communities. So Mr. Mopua has obviously been able to give us a bit of information that he's obtained from Gabriel Lynch in his testimony, in his report. But here the Chamber has the primary source, and I understand there's much of concern on the part of Defense Counsel, especially Defense Counsel for Mr. Sang, on the reliability of the information. We have here the article of Ms. Gabriel Lynch, and I don't see why we should be depriving the Chamber of this information in regards to elements and evidence which are highly relevant to this case, Mr. Moy, Mr. Ruto's political career, and all other elements which are concerned with the post-election violence. In regards to the prejudice or potential prejudice of admitting either one of these articles, actually the first one, this one regarding Gabriel Lynch, once again, I've looked over the article, and Ms. Gabriel Lynch doesn't go into the acts or conduct of the accused, doesn't pronounce herself on the criminal responsibility of the accused in regards to the charges that are before this Chamber, doesn't speak about any of the members of the network. And that's one of the reasons, Your Honor, that prosecution selected these two articles. They don't necessarily go into, they don't deal with these matters, which we would feel would be unacceptable, and we would have asked to have these tendered. That's why specifically we've asked for this article to be admitted into evidence along with the report. Then obviously you have the article of Jacqueline Klopp, and her article is an article that was published, what I see is 2007. Her main area of expertise is what Mr. Mopua was speaking about yesterday and today on different occasions, is this whole ethnic cleansing going on from the 1991 to 1993, which is actually quite relevant. There's been many questions that were posed to Mr. Mopua in that regard. Mr. Mopua, I think at one point even referred to his expert report and the fact that he had cited information in that regard. So once again, for Defense Counsel, this is information from where Mr. Mopua obtained his conclusion or arrived at his conclusions. Ms. Klopp, Jacqueline Klopp, deals with the 1991-1993 elections. She deals with the ethnic clashes during that period. She also deals with the usage of the term Madoa-doa. There's been evidence in this regard in this case already. I refer to the Chamber. She's also dealt with the electoral despotism that Mr. Mopua spoke about, Majimboism that she's dealt with, which is also a subject matter that has garnered a lot of attention during these proceedings. There were questions by the Chamber on that, lengthy questions by the defense. Prosecution as well has endeavored to find out more about Majimboism through the years. Ms. Klopp has done a certain investigation. She cites her sources, her bibliography. This could be of aid to the Chamber in determining the truth in this case, or at the very least, having at its disposal information, specialized knowledge, which could help it assess evidence that has already come into the file or evidence that is yet to come. So for both of these issues, as for both of these articles, even for the one of Ms. Jacqueline Klopp, once again, she does not. It's an article, obviously, from 2001, so she does not deal with the criminal responsibility of any of the accused that are charged here before the court or any of the members of the network. She deals with the Moy regime and everything preceding 2001. For those reasons, Your Honor, for the highly relevant nature of these articles, for the fact that there is no prejudice at all to the defense to a fair trial in admitting these articles, and also in light of the fact that they're highly relevant, I submit that both these articles should be admitted by the Chamber for the truth of their contents. Prosecution is well aware that it's sitting before a chamber of professional judges. If there's any information in these articles that the defense objects to, it's obvious that the Chamber can simply put them aside and not consider them for any ultimate decision in this case. Those are my submissions for the two articles, Your Honor.
Mr. Huber?
Well, trial by bibliography is an unusual proposition to hear come from a prosecutor. I can't think of any case where subsidiary source articles of this kind have been admitted in any case, and I don't know if the prosecution can. but I, for my part, can't think of a case where any court has gone that far, nor would it, or should it do so. It would be a breach of the Article 67 rights to confront witnesses. The prosecution, I understand, contacted Miss Gabrielle Lynch. We had a Rule 77 disclosure relating to a meeting, at least between the OTP and her. Have they called her? Have they chosen to call her? Am I, in fact, not cross-examining Mr. Mauper, but also Gabrielle Lynch and Miss Klopp and the various people who appeared, or the various committees and crisis groups and what have we that have been referred to. Now, originally we got a list of documents that the prosecution, I understand, wanted to seek to exhibit, which were numbered 10 and included at least 6, as Ms. Bisman has already mentioned, that appear on the bar table motion. Now we're down to 2. We're down to the Miss Lynch article, paper, and the Miss Klopp paper. Surprisingly, the prosecution want to adduce these for the truth of their content. Just pause there. What does that mean? Both of these papers are about 25, 30 pages long, replete with footnotes and references of various sorts and quality. 40, perhaps 50 pages between them, the two articles. So are all the statements of fact contained in those articles written by people that we've never set eyes on, never appeared before the court, are they going to be now admitted at the prosecution's request for the truth of their content? How would any accused, in fact, be in a position to address that kind of situation? Why not put in Miss Gabrielle Lynch's book? Where does it stop? So there are, we can tell, our reactions are the same. There must be some kind of restraint. If we look at the, can I take the Klopp article first? In fact, in the course of Mr. Mauper's written report, that is referred to just once. And it's referred to in the context of ethnic despotism. In her own article, she states that while this has yet to be systematically explored, a number of scholars have drawn attention to this thesis, political science theory. And she also makes reference herself to page 475 to quote the lack of careful local level studies of this violence. Now, in
Mr. Hooper, watch the clock,
certainly,
so you can yield some time
certainly
to your colleagues to also put
certainly.
in.
In respect of Gabrielle Lynch's article, again, it's a long and substantial article, and certainly neither Mr. Mauper has referred to it, nor has the defence. And there are matters here that would be potentially in breach of the restrictions of the parameters of evidence, and matters here that are plainly wrong. So, for example, of Ruto at one point it states he became the Treasurer of Youth for Kanu 92. No, he didn't. He was never Treasurer of Kanu 92. Take that as an example. Are we meant to now accept this as a statement of truth, unproven, unstated by the witness? And we also come back to the matters that were raised and touched upon in respect of this kind of material by Ms. Busman. And that relates, of course, to the general kind of material that we're dealing with, and where the prejudice, in fact, would naturally arise. And that is, apart from the fact that the defence, the accused, cannot confront his accuser if there are facts of accusation, and one assumes that the only probative value that these have are probative values in terms of the charges against the accused. Otherwise, there's no probative value. And the defence would be deprived of an opportunity of confronting either Gabriel Lynch or Ms. Klopp in respect of concepts, in respect of opinions which are based on material which is uncertain or unsourced, generally and commonly unsourced. The decision of the prosecutor's bar table motions in the Katanga case, decision 2635, considered, for example, and I just take it briefly as an example, the prosecution's request in that case to have reports by United Nations agencies admitted. The court had no difficulty in terms of the genuineness and authenticity issues, but it said, insofar as such reports emanate from independent observers who were direct observers of their facts being reported, the Chamber considers them to be prima facie reliable. However, if the author's identity and the sources of the information provided are not revealed with sufficient detail, the Chamber is unable to determine whether the contents of the report have been imparted by an eyewitness or some other reliable source. This all at paragraph 29. If such particulars are not available, either from the reports themselves or from their authors, the Chamber cannot assess the reliability of the content of the report. It is therefore unable to qualify these documents as sufficiently reliable to be admitted into evidence. Moreover, where such reports are based for the most part on hearsay information, especially if that information is twice or further removed from its source, the reliability of their conduct is seriously impugned. It went on to then consider reports from independent NGOs and basically applied the same or similar criteria. And throughout these reports, we have in an academic approach to issues, statements of fact, often unreferenced, upon which conclusions are based, which have helped mould our witnesses' opinion. Now, if I can come just very briefly and finally to the case which I referred to, or which I provided my friend with, and I think the court's got a Karadzic decision. Thank you. This is a decision of 9th of July 2010, Prosecutor Radovan Karadzic before the trial chamber, decision on the prosecution's submission on the relevancy of certain documents relating to the testimony of Richard Phillips, who's the expert evidence. And it reads, paragraph 5, and just pausing there, one must recall that at the ICTY there is a particular regime which we do not have at the ICC in relation to, first of all, experts' reports, the way notice is given to the other side, time for objection, etc., etc. And secondly, we have a different regime there also in respect of reliance on pre-trial written statements being admitted into evidence. So that those are very different circumstances to the one that we're in any event. But it does state, paragraph 5, what might be considered a general and practicable viewpoint. And it reads, is there a copy? I've provided copies for you, the judges. Expert reports generally should be complete and understandable in themselves, such there is no need to tender for admission into evidence the sources used by the expert. However, should the presenting party wish to tender certain sources used by an expert in compiling his or her report, it can apply to the Chamber for their admission, orally or in writing. Now, just pausing there, we're dealing with a very different kind of expert and very, very different kinds of source material. If you've got an expert at the ICTY who comes before the court to explain, for example, trajectory of ammunition, a military expert, he will come in and he will have the documents provided to him of the Army's use of certain caliber shells, or whatever it might be, positionings, trigonometry, positions, all primary evidence. Yes.
Mr. Hooper, that was a reminder that
Yes,
we've now passed the 4 o'clock threshold. Can you wrap it up, please?
Yes, certainly. I was just saying that we're looking here at a different kind of source material. We're talking about primary material that's provided to an expert in respect of particular technical matters.
And they could be actual evidence. That's what
Yeah, they could be actual evidence. We're not talking about opinion evidence. But even so, expert reports at paragraph 10, say the Chamber, provide the Chamber with synthesis and analysis of voluminous and often complex technical material by a suitably qualified expert, thus ensuring that the Chamber is not required to undertake the same task. As such, documents and other items that are source material are not admitted for their substantive content. Rather, the purpose of admitting source material is to enable the Chamber to verify, if necessary, the basis upon which the expert reached his or her conclusions, as well as how the relevant analysis was conducted. These documents are only therefore of assistance to the Chamber in determining the weight to be ascribed to the expert report. And in our submission, if these reports by Ms. Klopp or Ms. Lynch were to be admitted, they would and should necessarily have a great restraint exercised over them out of fairness for the accused and the fairness of the trial, and they should certainly not be admitted for their substantive content, and certainly not admitted, as my friend suggested, for the truth of their contents. Those are our submissions.
Is that you, Ms. Busman? Yes.
Thank you, Mr. President. I will be very brief. I fully share the observations just made by Mr. Hooper. Just one thing I'd like to add. Especially, we heard Mr. Garcia say that she was the primary source, so we also express our surprise that she wasn't called here to testify before you if she has such a great knowledge of the Kalenjin culture. But in fact, we know very little about her. We only know that we heard his opinion, Dr. Mapo's opinion on her research as well as on Klopp's research, and seemed more that he had a preference for her approach over Klopp's approach. It was more to do with European versus American style. And actually, if we look at his absence of real knowledge on Kalenjin culture, I'm not sure that his opinion on on Ms. Lynch as a source is so relevant, because she is actually his source. She is his main source on Kalenjin culture. And the only thing, he cannot, we have not heard anything about her methodology, we haven't heard anything about her sources. I can only look at her sources, and some of them are newspapers, others are Human Rights Watch, and it's the Ballots to Bullets again, the one that is also part of the application. And there is International Crisis Group, there is other academics who then rely on other academics, and I won't dwell on the point because I think they're made by Mr. Hooper. Just one thing, we only know one thing, and that is that she doesn't fully understand the local language, and she had to rely on people around her to interpret what was being said. This is something we know from the prosecution in their contact with her. And so we don't know how much time she spent there. We do not know how fully, she's not been an expert before you. She has not been qualified as such. So at the moment, it is an opinion that was relied upon by someone who was qualified as an expert. And that's the extent to which we accept that phrases in hers or in Klop's documents can be used, and it has been used in his testimony. There is no added value to also admit these academic papers. Thank you.
To our colleagues in the interpretation and court reporting booths, if you can bear with us for another 5 minutes so we can wrap this thing up. Mr. Garcia, 2 minutes to respond if you need to, or reply rather.
Simply, Your Honor, and even in this decision, Cardick, when you read the last portion of paragraph 10, I think the Chamber even notes that there might be situations. It says, the Chamber notes, however, that if at a later date a witness discusses the content of a document previously admitted as a source document in such a way that renders that document admissible for its content, its status can be changed to reflect its admission for all purposes. Obviously, it's at the end of the paragraph that Mr. Hooper cited, so it's not clearly closing the doors on any issue of possibly having a source document be admitted for the truth of its content. And I think that's important to note as well.
Thank you. The Chamber will not admit the documents. Chamber is sympathetic with the view expressed in the Karadzic case that expert reports generally should be complete and understandable in themselves, such that there is no need to tender for admission into evidence the sources used by the expert. But we're not making a ruling on that now. As I said, it's just a question of sympathy that we have for that view. It is enough to say that the proposition of the prosecution that the document should be admitted for the truth of their content is certainly not one that we will be agreeable to. That is the ruling of the Chamber. Thank you. Now, we will be rising now, and we'll start back here at 9:30 tomorrow.
All rise. We will be.